Welcome, everyone, to today's webinar hosted by InvestHer. My name is Liz. I am co founder of InvestHer, where we believe it is every woman's birthright to become financially free. So excited to be joined by Gwendy Wolfe. She's a senior attorney with Anderson Advisors, who's one of our trusted preferred partners and really here to be a resource to our entire community. So thank you for joining us. As we talk about growing our wealth and buying the next deal, those topics could get a lot of press these days. But this is actually probably one of the most important, less sexy, but really important topics as we build our wealth, because we can buy a property, put tenants in it, right? Regardless of the strategy. But then if we're really not protecting it with the right, with the right team and the right strategy, then all of our hard work goes really down the drain, if you will. So thanks for everyone being here. I would love to hear, before we just jump in and I introduce you to Gwendy here and get going, because we like to kind of start on time, end on time. I'd love to see who's here. If you could just share your name and where you're calling in from. And if you have an intention for today, the goal of every time we do a webinar or anything we do with the investor community is that you go in with an intention, you go in with something you want to get out of, whether it's a chapter, whether it's InvestHerCon, whether it's this webinar, right? We want you to get the most out of everything you do with our community. So I would love to hear what you're looking to get out of this session together. Hey, Marcy. I know Marcy well. She's one of our lovely Strive members. Hey, Malika Daniels from Atlanta. Thank you for being here. And if you're new, if this is your first ever kind of webinar that or event you're engaging with InvestHer on, please put new in there. I'd like to welcome you personally to our event here. Hey, Judy, Malika, thanks for being here. We don't take that lightly. So thank you for making time to be here. We want to make this as valuable as possible. So, hey, Jenny from Asheville. You're new. Awesome. Hey, Sarah from Atlanta. A couple people from Atlanta. Very cool. I was just in Atlanta. Well, welcome, everyone. We're going to get going so we make this time well spent for everyone. We are recording this. Without further ado, Gwendy, thanks again so much for being here. I'm going to jump back on in about 20 after so I can make sure everyone knows all the great stuff we're doing with InvestHer and how you can continue to get supported by us. But without further ado, Gwendy's going to talk about how to protect and optimize your growing portfolio. So thanks again for being here.
Thanks, Liz. I appreciate that. Okay, well, let's go ahead and jump right into it. I hope you guys can see my screen. During the presentation, if you have questions, I will look at those at the last 15 minutes-ish of the hour that we have together. So definitely participate. I do want to answer those questions. I want to be here to help you. And so while we're definitely going to have opportunities to meet up again, I want to make sure that you're getting the most out of today. And that is making sure that if you have specific questions about what I'm talking about, let's get those answers. Let's get those addressed. It's going to make a more enriching environment for everybody. Now, a little bit about me and this firm, but let's start maybe with my first experience with investors. I had the privilege to go to the Austin conference in June. And this is not just a platitude here. Every single woman that I spoke to showed so much resilience and grit and determination and this savvy and this hunger to grow their portfolio. But where they were in the stages of their portfolio was all very different. We had people that were just starting, that were starting in a position where maybe their emotional personal lives were blowing up, but that only motivated you guys more. And I understand being an investor can be riddled with a lot of worries, right? Well, I am such a good worrier. I'm so good at what I like to call issue spotting, right? The worries help me protect myself, but it also makes me feel like I need to be an expert in every single topic that I'm about to encounter. And so I'm an attorney and I did love my education and it does help me with a lot of things, but I'm not an expert, let's say, in giving birth For my my firstborn, I felt like I needed to become a midwife. When I want to get my hair cut, I have actually taken courses to be like, can I do it myself? Because I want to have control. I'm so afraid that somebody else is going to mess up. I only trust myself. But here's the thing: you may not be an attorney, you may not be a CPA, you may not be a business advisor, and it's a little bit different than cutting your hair. If I cut my hair, I know my bangs are gonna grow back and I'm gonna look normal again. But if I mess up my investment that I may have been scouring for years, right? We go through such a process of trying to find the right properties, trying to find the right local areas, trying to get financing, funding, trying to just get the nerve to purchase and to go forward with our plan. And if you don't set it up in the right ownership structure, it is something that if you lose it, it's gone. It doesn't grow back. This is not hair. Cut your bangs all you want. Don't set up your business entities without talking to an expert. And this is something where we have a firm that is very focused on education because, yes, we know that it's scary. There are so many factors that are going to come at you. But there's also a way to defensively position yourself to optimize the portfolio, to protect it, and to minimize taxes, maximize profitability. And so that's my goal here. This is my aim, is that I'm teaching you some core skills, helping you to avoid mistakes. And I have seen it all across the board with the kind of mistakes that our clients make. And so, I mean, I spend every single day talking to my clients about this, how to do it right, how to fix it if I did it wrong. And hopefully we're catching it in that moment so that if somebody does, trip and fall on your estate, or you're being personally pursued by a creditor, we're not losing all of our business assets. We're not losing the work of 15 years. And again, I have absolutely seen people with 500 units or 40 rental properties, and they have been in the business for decades, but they still needed our help. They still needed to clean it up because they got one bad piece of information. And guess what? They spent their time doing things that make them money, things that if you're a real estate investor, you're probably great at that. Make money doing the thing you know how to do. Don't waste your time trying to get a law degree on the side. Keep your soul and rely on the expertise of professionals like me or like other law firms. So I'm going to try to educate you about how to communicate it, right? We can go on Pinterest and show our haircut. Well, this is what I want. Well, I'm going to show you something that you can show anybody, whether that's Anderson or that's somebody else. I want you to have something that gives you an idea of what you should be doing. Now, it's very particular for every single person, what kind of asset it is, what your plan to do with it is, what kind of income it is, whether that's passive or active, and then where it is. So we're going to go get into all of that. I've kind of alluded to it, but I am an attorney. My name is Gwendy Wolfe. I'm one of the senior attorneys here at Anderson. Well, at here, meaning like here in my remote office. But at Anderson, I am trusted to advise our clients on a multitude of issues, and that is asset protection. That's helping them pick the right tax selection. That's helping them set up their estate plans, drafting those estate plans for our clients, helping set up those nonprofits, and answering all the questions about business planning too. So I came from the dark side. I came from private practice, about 7 years of private practice. So I've definitely had my devil horns on and have been litigating, throwing frivolous claims out on the behalf of my clients that were angry, that didn't have claims, or that had meritorious claims. And I've seen both sides of whether you're losing the case or whether you're winning it. But let me tell you something, only the attorneys are winning it. And so it's a pleasure and a privilege to be here, not having to charge anybody $500 an hour and just getting to educate freely. Now, I came to Anderson because we have that special model of where we want to help our clients learn these things. Now, it was formed in 1999. It's been a while. And it started out as really just an educational firm founded by Clint and Toby. So Clint came from the litigation side like me, and Toby came from the tax side. So he's a tax attorney. Now they realized that these two things link together. And so between them, they had about 500 rental properties. And they realized that this is something that people not only needed to be educated on, but also needed support and a system to help them set up the right thing. And so flash forward to now, we have a huge business across the United States serving every single state to help educate and create structures and legal entities that can appropriately own your assets. And not only that, we also have other ancillary services to help maintain those companies, maintain anonymity if that's an option. And then we also do the full plan, right? We're also doing the estate planning, and we're also helping you with our tax preparation and tax consulting and bookkeeping. And we don't just do the bookkeeping, we can also just teach you. And so there's lots of things here, lots of services and lots of systems in place. And this is something that I want to reiterate, is that you don't have to do this all by yourself. I have a whole team that I work with to make sure that the suggestions I'm giving our clients is something that is cohesive throughout all of the different types of areas of law, and then it makes sense on all fronts of the business. And that includes, business planning, but tax planning and bookkeeping. These are fundamentals of any business. You're already an investor or you're about to start, and you're here learning, and you need to continue to take this journey seriously. You are a serious investor. You have demonstrated courage and wits and grit. You are here, and you need to continue this journey. What is already in motion will continue to stay in motion. So keep this ball rolling, whether you want to do it yourself. And we have clients that do that, and they just want a little educational help. We're here for that whole process. Now, how to figure out what if you have the right legal structure to own your assets is we've tried to create a risk analyzer, something that helps you assess the type of asset it is and put it into a category. And so when I'm thinking about risk, I'm thinking about it from the litigation side, right? If I have a contract and I owe obligations to somebody, I owe services, I owe money. You guys are real estate investors. The most common situation here is tenant landlord, right? Those are contracts. So if there is a potential for a breach of contract, then that's a lawsuit. A breach of claim means I can take you to court, or I can just file a bunch of demand letters, send them to you, and scare you and get you to pay me off of a frivolous claim. This is part of the whole picture for the litigation game. And so this is something that we are really fully considering when we're making these recommendations. So whether there's risk, meaning there's a contract, there's people tracking on the property, right? There's a difference between a brokerage account. No one's going to slip and fall on my E-Trade account versus I have a rental. Somebody slips and falls down the stairs of my apartment complex that I own. These are things that we are looking at. So there's a range of what kind of risk is associated with the asset. And then there's also just things that are personal investments, or sorry, not personal investments, but personal assets like your car. It has no business use. It's being used just for you. We don't want to put that in an LLC with actual business assets, because now we're weakening the protection of the LLC. And so those assets have their own place, their own legal entities that are not going to contaminate any other kind of business asset or property. So we're looking at risk, whether it's business or not, and then what kind of income it is. If it's active business, right, we are thinking about it in okay, should this be an S or a C Corp? That's really the big question. And where am I doing business? Where am I entering into contracts? Is it with a company or residents of one particular state? We want to make sure we're formed in the right place. And it goes back to contracts. I want to be able to enforce this contract. So I need to be set up in the state where I'm doing the business so that I can bring it to a court and say, hey, Make this guy pay me. So this is the risk analyzer, right? This is something that we're just doing every single time we're thinking about how do I structure it. Well, these are the questions we start off asking. Now, a great plan means that you're doing all of these things. We are doing asset protection, legal structures, right? We're putting our assets properly into the right legal structure. And when I'm talking about legal structures, I use such a broad term because there's so many types and we all colloquially call them different things. But legally, on a state level, we have laws that govern different types of legal structures. Those are limited liability companies, corporations, statutory trusts. Those are trusts that are actually registered with the Secretary of State and are allowed to do business. They have springing company options, springing LLC options, which means if it is sued, you have the option to convert it into a limited liability company to get more protection. Now, that's a lot. You don't have to remember this, right? If you want to do it yourself, I hope you're jotting it all down or you're gonna watch this recording later. But it is a lot. It's a lot of different rules involved. And so part of that asset protection and the business planning aspect goes together with a legal expert. Okay. And so if you don't want to be the legal expert and you want to spend your time making money, hire somebody. And I highly recommend you do that, whether it's us or somebody else, but you need an expert that knows what they're doing. And then we have the tax planning, right? You got to have your bookkeeping records ready and the tax. If the books are good and you've been diligent about tracking and staying up to date on it, then you're going to know in December, do I withhold, do I say, hey, tenants, you can pay me next year because I'm trying to avoid a certain increase in income and I'm trying to maximize my deductions and I'm trying, we've got lots of fiscal planning to do throughout the year so that in December, we know anything else that we can do, right? We've got 30 days to do it. We can't do all the tax planning that and consolidated into that last month, right? If you haven't been keeping track of it for 11 months, we don't know what we should be recommending. And so the tax and financial planning aspect of your investments is such a critical piece if you're trying to make sure that you're keeping the most profits in your bank account, right? There are lots of legitimate tax codes that allow you to actually have deductions or to lower that taxable bill or to do some income shifting with your own entities and make sure that you legitimately get to keep those funds. And even if you're audited, right, we have legitimate laws that allow you to do these things. So I know that if you've ever heard of Anderson before, some people think that we're creating loopholes. And I don't like that word. It's not a loophole. It is the law. And so if you have an expert that knows the law, then you're going to be able to keep the most in your pocket. Critical pieces to this. But then we also have estate planning. And I'm going to talk about this at the very end, probably like 10 minutes. But we have a full plan, and it is a comprehensive plan when we are also protecting those people that we're leaving behind. And a good estate planning tool, one that is going to help your kids avoid probate, is critical to completing this asset protection plan. So threat planning, I've kind of already talked about it, but defensively, we're thinking about what should we do? How do I tend the goal? I used to play soccer. So we tend the goal. And so I need to have a plan that if I am sued or there is a personal creditor or there is a business tenant trying to sue me, I have the best structure to have an attorney go and, a lawsuit's filed. But we're going to settle that for a lot less if we are coming from a strong defensible position. And I've talked to many of our clients that have been sued still. There's got to be somebody that is representing the company that is engaging in the contracts, engaging with the tenants. There will be somebody named on that lawsuit. But when they go to try to scare them in settlement, you have an amazing structure that says you can only get what's in this LLC. I have 50 properties, but you can't touch any of those. It's just this. And so I have talked to at least 3 clients in the last quarter that have been sued and have brought their structure, this picture, to settlement. And that is what has really protected them from having to go forward with spending, $500,000 in attorney fees, trying to take it all the way to trial to dismiss frivolous claims. We're doing it on the onset. And that's what's going to really help you with the litigation games that are played. And that is something that you need to be aware of on that forefront. So as I mentioned, there's lots of frivolous claims. 84 million number of lawsuits that are filed every year. We're in a litigious society. That is part of putting on the devil horns and being an attorney at a normal private law firm. It's all about getting that attorney paid, and they know how to twist it about so that no matter what, you have to find that sweet spot of settling just a little bit under what it would actually cost to take it all the way through trial. And so, of course, it's not just money, right? It is an emotional drain as well. I don't know if anybody has been sued before, and that's something that you're definitely welcome to tell us, but it's 80% likely that a business owner is going to be sued. So even if you've been 20 years, you're 20 years lucky, but it's going to come to you. And I have more stories for that. So let's talk about, I'm just trying to think here. I have some structuring, and I'm going to do a little bit more educating on the types of liabilities. And then I'm going to show you what we're talking about. And then we can kind of go through the mistakes and then look again at the diagram that I've tried to illustrate these concepts for you. So we have 2 types, okay? It's asset-based liability, means that there's a liability directly related to the investment property. So that's a slip and fall, it's a tenant, it's that claim that you have, that contractual legal relationship you have with a tenant. Whoever that landlord is who's going to owe. If it's a property owner, that's yourself as an individual, and then you have a tenant that gets hurt, or maybe one of their guests, they can sue you. And that means if it's in your individual name, they get access to everything else that you own. You are the ultimate gold pot here. And we want to separate out that ability to reach every single asset that you have to help you be protected. And so separation here is key. And here's one rule that I'm going to say. It's not in my slides. You have to listen. So listen up, look at me, stop what you're doing. I know you're probably answering emails and maybe cleaning the dishes, and stop. The best rule I have is separation. Okay. It's a 1-to-1 ratio. LLC to asset, tangible asset. That means my real estate property in Utah and Texas and California should not be in the same LLC, because if something happens to the Utah property, we have the Texas LLC and the Texas property, and the California property is now at risk. And they were fine. There was no issues with those, but now we might lose it all. So this is the rule. It's a 1-to-1 ratio. Separate, separate, separate. Okay, I'm done. I'm moving on to the next rule. I just want to nail it in here, because this is something that our clients don't want to do. I had a live teaching session a few weeks ago in Vegas, and I had a client that had literally $13 million worth of investment properties in one LLC. And he's like, I don't want to do more. You guys are recommending that I set up 7 different LLCs, and I don't want to do it. I'm like, okay, you don't have to, but after I'm done talking to you, you will want to. And he told me that he felt like he was standing at the edge of the cliff, and I was about to push him off by the time I was done talking, because it is the risk. You're risking $13 million when instead the risk could be maybe $1 million. Now, that's still not a great scenario, but you didn't lose. 20 years of work. You lost maybe 2 years of work. And that's something that we can recover. So again, that rule, if you're going to walk away with anything, walk away with that. And then we can fix all the other mistakes you might make with that rule later. So with asset-based liability, we have some liability concerns. This is a short list. I'm not going to go over all of these things. I will give you a little story though. Same guy hasn't deeded his properties yet into this LLC. This is still in the beginning stages of the plan, but he has a tenant who is, I believe, a lawyer, which is the worst kind of tenant you could have. But he is, his child got some lead sickness. Now, in California, there are certain notices that you give to the tenants, some warnings, and this guy's trying to renovate the rest of his building to bring it up to code. And he's already done everything that he can. This is the last tenant in the building. It's always the last tenant. That's the issue, right? The guy that doesn't want to go. And there's problems. And there's going to be legal claims that come with that. And so because his kid got sick, he has medical bills, he's an attorney. He knows I have damages. I'm going to try to make you pay me. Now, my client had those claims dismissed, but this guy just kept filing claim after claim after claim. So a new lawsuit. I think we're up to 3 lawsuits. This might be the last one. But here's the thing. Even after you then transfer it into its own little LLC for this property, it doesn't matter, right? The liability that was against him as an individual gets to continue. A legal claim has a life. And so that life usually, especially if it's an injury like this, like lead poisoning or mold, where it might be something that's not particularly defined yet in case law, right now it's indeterminate. We don't know how long these claims are going to live. Now, if it's something more normal, like I decided to jump off the second story into the pool and I broke my leg, right? We know those types of claims last for about 4 years. But still, we could say, okay, that guy got injured. I'm transferring the property over to my LLC, but you're still individually liable to this guy for 3 more years until that claim dies, because you were the individual landlord. You made that contract and that relationship with him as a personal individual. So it doesn't matter what the structuring does, because this person has access to the largest pot of assets. We don't want that. So you can screenshot these concerns. I'm sure your wonderful brains are great at making them up while you're trying to go to bed at night, just like mine. As all of these slides, right? They're all about the risk. The risk there. I have personal stories from clients. You can just go look it up in the news, and you'll just a quick Google search will bring up nightmare fuel for you. So that is similar, right, to the lead poison is the toxic mold. Now, you probably already have insurance, or if you don't, you absolutely should. But that's the first line of defense, right? If I have an umbrella insurance policy and it covers the property, right? It covers the property owner. That's great. An attorney is a personal injury attorney is what they're called. And they will go and they work off contingency. So anything that you win, because you have X amount of damages, the rate is about 30% that they're going to take as a contingency fee. And so that means if you get $12,000 from the insurance company, that attorney is taking 30%. If you get $1 million, that attorney gets 30%. Now, this is like a conveyor belt of money for the attorney. They don't care. As long as you have like normal damages, they're just going to ask for policy limits, clean off their hands, and move on to the next case. But when you have somebody that has potentially died on your property, we have a client that had some work done on their property, and the worker was getting electrocuted. He was standing on a ladder on one of those electricity poles, and he was getting electrocuted, and his buddy came and then all held onto the ladder. So what do you think happened? electricity, he also died. They both died. They both got electrocuted to death. Now that's just horrible, 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 horrible. But to an attorney that does personal injury claims, their eyes are lighting up. You're a real estate investor. You own all these properties. I found it all on public free searches. And now we have two people that have died. That is well beyond just the damages of my doctor visit, right? Now we have a full family that is going to make a wrongful death claim. And that's going to stick. That's going to be presented to a jury. The juries can award millions of dollars. Now, whether you can pay that or not, whether that judgment is going to attach to you personally and all the assets that you might ever own, or it might attach to just the LLC. So what's the better deal? You or the LLC, where you're like, okay, fine, I lose this property. Now, it's unfortunate that somebody died, but does that mean that you should lose everything? That your family should lose everything? I personally don't think so. But ethical and moral debates this is not the time for it. So first line of defense, insurance. But now how can we make it better is to make sure that we are putting those investments in the right legal entity and getting it out of our own name.
Quick question, Gwendy, do you mind if I jump in just with a question from someone here? Shayna, I'm hopefully saying your name right, but I'm sorry if I am not. But she's asking if the property is in an LLC, right? What type of umbrella insurance would she need? Personal umbrella only covers what's in their own names. Is that correct?
So it always depends on the policy, right? We have a primary named insured. And if it's an LLC, you don't have to name the members or the managers, because the way that the scope of the insurance policy works, it's going to automatically cover that. If the property is in an LLC and you have umbrella insurance and it doesn't name the LLC at all, that's a problem. It needs to name the LLC, and the LLC may not be able to still get coverage if it's an additional insured. It might actually have to be the primary. So that's something that you need to work out with your insurance agent. Our insurance affiliates say that the LLC for the people that they work with would be covered as an additional insured, but if it's a trust, then it needs to be primary. So there are lots of nuances. That was something that we learned 2-3 months ago, just a new change. And so, especially with the latest devastations that are happening, if you have property that's in a hot spot like California or Florida, where you could completely lose the property, you need to make sure that the umbrella insurance is going to cover those ancillary natural disaster type events, and that you have confirmed in writing that the LLC or whoever's named in whatever capacity is also going to be able to get their claim paid out. Huge part of business planning is the insurance. Now, this is a list of things that insurance is not going to cover. Unless you do have an umbrella insurance that might cover, I know I've seen them that cover trampolines, or you got that four-wheeler or the pool or other things like that, but it gets really costly. And if an attorney does see all these additional umbrella insurance coverage, it might actually make things worse. I've heard it both ways from our clients. So really depends on the legal assistance you're getting when you're defending the policy or the beyond the policy limits of the claim. Now, because of these extra things, right? The insurance company, they're going to pay out maximum of the policy limits. Let's say it's $1 million. But again, if somebody dies on your property, that claim might be multi-million. They're going to still sue you if the policy doesn't cover their actual damages. So be aware of that, right? And this discussion goes to just reiterate how important it is to get it out of your own name. You want it in an LLC. And then, yes, you want that insurance. I thought that's such a great question. You want the insurance policy to make sure it names the property owner. Okay. We are, I'm so sorry. I'm going so slowly here. I'm going to kind of run through these mistakes because I want to make sure I hit the estate planning piece too, and we get some time to do structuring and then just open questions. So I mentioned this mistake already, but you bundling all of your real estate investments into one LLC is a huge problem. If somebody gets hurt on property 1, property 2 and 3 are now affected. They're potentially completely exposed to loss. And I want to go back to this too. I have clients that are not just having real estate investments in one LLC, but they're also like doing their Etsy business with this LLC. Well, you're now impacting, and it may be like a drop shipping thing, right? That's like super common right now. I make an order, I don't even hold the inventory, I don't have any tangible assets. So why is that a problem? Well, it's an income stream. You're getting money from this source, and now you put it in an LLC where there's other unrelated exposure. And because of that unrelated exposure, now whoever is getting that judgment against you, they are able to intercept all the Etsy money. I don't want you to do that. And that's the problem too, is that we want it to be separated from not just tangible assets, from other income streams. So I'm going to clarify that rule a little bit. Separate, but again, if you can't remember any details about that rule, remember separate. Just separate it. Which is why I'm going to say it 14 more times. No. Okay. So we have passive investing, and this is the structuring piece of it, but this is a problem, right? We've got all eggs in one basket. I've gone over this so many times that I'm going to fly through this. Now we've got the better approach. And so you want different LLCs for different properties, 1-to-1 ratio. And so this is what that's demonstrating here. If you want to take a screenshot, take one now, because this is prettier than what I have made, right, Liz? She saw it earlier. Okay, we have, so this is about passive. You're going to see that for passive income. And so there's a different way to hold something that has passive income, and then a way to hold something that's going to trigger dealer status with real estate. And you trigger dealer status, which essentially is an extra 15% of tax that the IRS is taking from your profits when you are doing flipping. So that means you purchase, you might be at a tax lien auction, it might be a wholesaling thing, but the IRS is looking at this and saying, okay, she got this property with the intent to sell it. And that intent, whether you ended up selling that the next day or 30 years from then, there's many IRS publications that state that that is considered dealer status. It's about the initial intent. So if your initial intent was to sell it, it's inventory, and they're going to take that extra 15 from you. Avoid that. So we have structures where we are using a active holding company, right? The active holding company is like, think of it like your tax saver holding company. It's to help you avoid that additional dealer status. And we like to do that with a C Corp because a C Corp is different. It's a different taxpayer. Every other kind of tax election you can choose for your LLCs or your corps, right? We've only got 4 kinds. If it's a single owner and it's an LLC, it's a disregarded entity. If there's multiple members, partnership, those are the defaults, right? But an LLC can wear any hat. So it can also be treated as an S Corp, which again, those all are passed through. You are the responsible taxpayer for that income. That means even if you kept all the money in the LLC and you didn't take any profits, you're still being taxed on it because you're the responsible taxpayer. The only one that's different is the C Corp. The C Corp, if you don't take money out of it, you're not getting taxed on it. And so when we're doing something like flipping or wholesaling, where our intent is to then go take that money that we made and then go buy another property, well, let's not pay taxes on that. Just reinvest it. And because that C Corp status doesn't, if you have these profits, but you're not taking them, that means you just get taxed at that flat 21% rate. That's probably lower than yours. Easy math. I didn't go to math school. I went to law school, but even I can do that. 21% is way better to reinvest the profits. So this structuring is good for taxes, but then we also have the risk for liability. So in private practice, I had a case. Partner was so furious. He came in and he's like, I don't even care if I have a claim. I want you to subpoena them at Thanksgiving and at Christmas, and I want them to be embarrassed. I want them to feel pain because they lied to me. They told, like, they didn't disclose that this was built on a garbage dump, and now I have to pay an extra $3 million. This guy, he had millions and millions of dollars liquid. Like, he was a very rich man, but he didn't care. He was mad about how this messed up his deal, messed up his budget. And so it was something that the person that did the deal with him, they sold the property. They felt like they'd wiped their hands of it, but he didn't care. He's like, let's put that knife in and twist. I want them to pay attorney fees, even if it means that I lose. I don't care. And so if this person had sold it through an LLC, and then we dissolved that LLC, this angry guy wouldn't be able to do anything. The LLC's gone. There's no money in it. So sad. Too bad. Move on. But unfortunately, I was the attorney that was embarrassing him at Thanksgiving with subpoenas and process servers, but that is part of it, right? And so we want to minimize risk with people that are going to come back afterwards. So that was pretty legitimate, right? It raised the budget by about $2 million to fix the garbage dump site so that they could build their development property on. But I've also had clients do sales, and then their buyers come back and say, hey, I have to fix the roof and I want you to pay me $3,000 to fix the roof, but this deal is closed. But because they sold it in their individual name, they got to deal with this as an individual. If they go to a lawsuit, there's no way to avoid this. And so they're going to, it's not a defensible position. So using the LLC, using these structures is what is going to really help you minimize risk. And risk is the lawsuits. It's having to get pulled into the game. So that is something to screenshot. Okay. All right. Mistake number 2, we're using the wrong type of entity. I'm using a C Corp for a rental. I'm not going to get cost seg. I'm not going to be able to do depreciation. I'm losing tax benefits. I'm putting it in the wrong state. I've got a Utah property and a Texas property, and it's all in an Ohio LLC. If I want to evict my tenant, I can't use Texas courts or Utah courts, and now I'm stuck. There are other penalties and fines, but let's be real. Why you really want to choose the right state is because you want to be able to enforce your contracts and your legal rights. Now, this particular issue also goes to charging order protection, which we've talked about the asset-based liability, but now owner-based liability. That means I owe American Express $50,000. Oh, okay, so they get a judgment against my name. I want to protect my business assets. How do I do that? Only an LLC is going to provide this kind of charging order protection that's going to limit the ability of that creditor to force a distribution, to get their hands in your books, or to review your company records, or to appoint a third party to start voting on your behalf, or potentially taking the company completely. We don't want that. We want to protect the business assets, and we want a way to control how that money flows out. And so charging order protection is crucial. There are only a few states that have charging order protection that's really going to benefit you from a personal creditor. That's Wyoming, Nevada, and Delaware, that have tested case law that will protect you. But if you put all of your assets, all of those different properties, let's say a Texas property, a Utah property, a California property, you do register it in, you have your Wyoming LLC because you're like, hey, I want that charging order protection, but now I've registered it in Texas and Utah and California because I want to be able to evict my tenants. But now we lose the charging order protection. So you do some layered ownership. Now, we haven't gotten to that piece of it. I am so short on time, Liz. So I'm gonna fast forward here. I'm gonna do the whiteboard. I have done this presentation before, and everybody's always very sad to miss that piece of it. Now, I will bring it up. Actually, maybe we can't do that now. The option is
I'd be
not.
able to help you, but I don't know if I can help you where I am.
Yeah. I promise we tested this. Okay, never mind. We're gonna stick with this. I think I'll have to stop actually presenting this in order to do it. So let's see what we can get through here. If you're trying to get charging order protection, the most famous case I can think of is the Grandma Sycamore case, where they did have a holding company set up in Wyoming for the charging order protection laws, but then they drafted their operating agreement to force distributions. So what does that mean? That means the creditor is going to get regular distributions, and your charging order flexibility you have in the state of Wyoming under those laws means nothing. So you need an operating agreement with these essential provisions. That's one here, right? No charging order language. It's number 4. There are other really important provisions, especially if you're partnering with other people. You want to make sure that you're considering all of these things, especially if you're running multiple businesses. These all have an impact on if it is being scrutinized by a third party. You need to make sure that everything lines up. And so this is another good screenshot here. Okay, I'm going to move on. All right, so this is the layered ownership I'm talking about. We've got Wyoming LLCs, and then we have LLCs that it owns, children companies. These are going to be disregarded to this Wyoming LLC. We're going to have, again, you see that separation here on LLC number 1, LLC number 2, and a syndication interest. Why? Because they're all different business income streams. They are all different assets that could potentially be taken. So we don't want to expose liability to our other assets that have nothing to do with the liability issue. All right, and then we have our mistake number 3 is anonymity. So another point for Wyoming and Nevada and Delaware and about 24 other states. So there's about 20, it's half and half. I've looked through all of them. State laws, Secretary of State, where you register and form and then maintain your company, whether that's an LLC or a business trust or a corporation. This all has to be registered with the Secretary of State. And the Secretary of State requires different things about the members or the shareholders, the managers or the officers, the people that are in control of the company. And so some states don't require it at all, or they only do when you go to renew it, or they require everything. And for Wyoming, we love it because it has great charging order protection. It's pretty compared to Nevada and Delaware, right? We're looking at also the cost of maintaining it. So it's about a 10% cost of, say, Nevada or Delaware. So we're looking at $60 versus $600 to keep it in Nevada and Delaware every year versus Wyoming. Same laws, same protections, and also same level of anonymity. They only want to know your business address and they want your registered agent. So what do you need? You need this entity to be a blocker for you. The Wyoming LLC not only provides charging order protection, it also keeps your name off the records. And why is that important? Well, number 1, people are looking. If they're wanting to sue you, they're wanting to see, is it worth it? Do I just settle on insurance policy limits, or do I try to get you for everything? I know you own 50 properties. I think you can pay off a frivolous settlement. That is, and of course it's a lot harder to sue you if they can't find you, but it also, you're not an attractive lawsuit if it looks like you're on food stamps. This is an example of the information that Wyoming's going to require. California, sorry, Wyoming's the next slide. So there are 2 other aspects, right? We might not show member or manager, but we are going to show the business address, the registered agent. You still don't want your name on those documents, and you don't want them as an organizer either. So you want to make sure that you have used a third-party service here, especially if anonymity is your goal. Regarding anonymity for the FinCEN requirements, I see your question. FinCEN is very localized to different agencies for the process of avoiding white collar crimes and embezzlement and fraud. And so only particular agencies get to have this. information. So I would make the parallel to the IRS, right? We file taxes every year, but this is not public information, but it is required. And it's the same kind of thing. FinCEN is another governmental agency, and you are required to report, you're required to update, but it's not something that is public disclosure. And so when we are talking about anonymity, it is worthless to make yourself crazy thinking about all the different ways to pull your name off the records. If you own anything, you can't just live in your bungalow off the grid. You are on grid, okay? But we are thinking about anonymity for public records, and that's going to be Secretary of State records, and that is going to be property records. Those are the two public databases. And so make sure your assets, if anonymity is your goal, that we are looking at how to make it anonymous on those public databases. Yeah, you're so welcome, Sarah. Thank you for participating. Okay, so trying to keep it together here on time. So we're going to go through, I'm going to let you do a screenshot here. So again, we're doing layered ownership with that Wyoming LLC, that an owner entity can be registered anywhere. The ones that need to be state specific are where your property is, okay, where you're doing business with residents, where you're doing business with companies. Those are local to the state. There are some exceptions, and that's why you should go and talk to an expert just to see how your plan might differ. And even these suggestions, these are basic, right? LLCs for these properties might be a great option if you're in Utah or Arizona or Texas. But if you're in California or Florida or Tennessee, there are other options for you because there are specific state laws for different taxes. And we want to make sure that you're keeping the most in your pocket and using the right or the best legal entity for the investment. Mistake number 4, we already talked about this, owning it all in your own name. Terrible. Now, it's terrible on two fronts, because if there's a problem and you're being sued individually, there's no way to avoid it. You can't escape it until that legal claim dies. And if it's something like a mold claim or a lead poisoning claim, they're indefinite. There is potentially no end to that until they create case law, and somebody has to go pay for that. So right now, if you get a mold claim and it's an individual, you just have that over your head. Avoid it. Put it in an LLC. But here's another reason. Anonymity really helps you, because I'm sure you have a home, okay? So you can't put that in an LLC. It doesn't have a business purpose. If you put that in an LLC with other business assets and somebody tries to sue you, you've commingled. And what that means is that somebody can pierce through your LLC, and it's like you don't even have one. So you want to keep it separated. Now, you can put a personal residence into an LLC, but that's a very expensive way to get anonymity. So you can do a privacy trust, right? Not one for estate planning, but one just to keep your name off the record. And so why would you do it? Now, I have a client, this is a screenshot of an actual news article about a tenant threatening the landlord and giving death threats because they wouldn't return a security deposit because they damaged the property. I have a client who has 500 units in Massachusetts, and they are shutting down, and they're going to demo the building. They have all their tenants out, and I said this before, but it's always the last tenant. This one he's not really been a problem for like the last 10 years, but he's becoming a problem now because the lease is over and they're going to knock the building down, but he doesn't want to leave. And so he's been threatening my client. 2 weeks ago, she had to get a restraining order, and she did it because the VA office called and said, in a meeting with their tenant, to say, hey, he's been making death threats to you about you, and we have interrupted our meeting to step out and call you because we think your immediate safety is at issue. And because they did that, she got a TRO. But he knew where she lived because it was on public record. He just searched her name. And so that is one reason why you want to have anonymity, even just if it's for your personal residence. And that's because of real threats, right? We have crazy people out there, or people that are temporarily unhinged, and we want to keep ourselves protected. These are some trust basics. I'm not going to get into them now. Fortunately, I have a part 2 that's coming up in December, and so I'm going to have to hit up on these points. I think we're at time.
Yeah.
Yes. So I guess 3 whole minutes to
Well,
question.
I want to make sure we answer one of these questions too. Sarah, I think you asked the follow-up, or you fielded the follow-up, Gwendy, but she also asked, how should the underlying financing be considered when deeding a property from one's personal name into an LLC? In particular, when the conventional mortgage is in one's personal name.
Okay, that's a great question.
Yeah,
So
that's a big one for our community.
it is. It's a big one for our clients too. You know, we've set up 60,000 LLCs over the last decade. Most of them have financing. So Fannie, if it's a Fannie or Freddie loan, those guidelines allow for you to transfer to an LLC that you own and control. Even if it's layered ownership, if you are the beneficial owner of it, then that's going to be allowed under the guidelines. And it had been unclear for years, right? It was like an unwritten allowance. And then in December of last year, they actually updated their guidelines. So you can go and look at those if you need some comfort.
Is
Now,
that just Franny? Is that just Franny and Freddie, or I guess
it,
that's really the most conventional. Yeah, on the conventional side, not necessarily the private
other
side, but yeah.
side. Yes. So here are some other ways to deal with that, because you might have a lender that doesn't let you do that. And so what is allowed is, under a federal law, you are preempted from a due on sale clause or an acceleration clause. So this means an unallowed transfer was made, and the lender has the option to say, okay, you have to pay me right now. That's the acceleration clause or the due on sale clause. So a transfer to an LLC would trigger it. But this federal law allows for you to make a transfer to what's called an inter vivos trust. If you go look it up, it is called the Garn-St. Germain's Act.
Say that again, slower.
Sorry, I think I even mixed it up. It's the St. Germain Garns Act. I'm gonna pull it up. So Garn St. Germain Act. I'm gonna put it in your chat. Okay.
Yeah, put it in the chat. That'd be great.
Okay, so there are different things that fall within this act that you can do to essentially get preempted from the transfer. But one thing you can do with ownership is transfer it to an inter vivos trust. An inter vivos trust is a revocable grantor trust. You most commonly have heard of it as a living trust or a family trust, but we can also create what's called a nominee trust or a privacy trust. And it is a grantor revocable trust, but its goals are a little bit different. With your estate plan living trust, where the goal is estate planning, it's named after you, and you have to be the trustee of it, because you should not give access to your assets with a fully funded trust to anybody else. But with a nominee trust, one that's like 8 pages, and it's just going to be called, the 1515 Hickory Trust because it's named after your property, that can have a trustee LLC that's your company. It can have a nominee trustee that's an attorney that's going to resign after you file the deed. So we're getting some anonymity there. And we're also able to transfer to this trust and meet the federal law exemptions that would essentially allow for your mortgage requirements to still be maintained, I guess. So I would say that is called a loophole. Now,
yeah, if you wouldn't mind putting that in the chat box, I think that would be great as we wrap up here. I want to be mindful of getting everyone on their way on time. And there's so much to this topic, right? And I'm sure you could probably speak for like 9 hours and we'd be all like, what? Because there's so much to this. And that's why the importance of having good counsel on your team and people that really know are in the trenches is incredibly important. And Gwendy, you certainly are one of those people, and you really want to surround yourself and engage with people. I know you're offering a free strategy session. I put that in the chat box. I think you've given everyone a lot to think about. I'd love to hear in the chat box very quickly your one takeaway. You know, everything we do in Investors about what is your intention, and then what is one action, one small action that you can take as a result of the content, the knowledge that you just learned, right? So we're not just in theory, but we're actually taking action to not only grow our wealth but protect it, which I think is such an important topic, especially for the women in our community. So I'd love to see in the chat box some takeaways and just some thank yous for you, Gwendy, and your I've never heard of this act. I'm gonna just copy and paste this myself because I'm like, that's very interesting. I'm not familiar with that. So a
Yeah,
lot of
we love
loopholes.
that one. A lot of our clients do it. It's gonna be in some states, like I mentioned before, like Tennessee or California or Florida, they have some particular rules where using a trust as the owner instead of an LLC is actually
Yeah.
much more beneficial to you. So it's a twofold benefit. I would love to talk to you guys more about it. I have a part 2 December 19th here, and so I'm going to try to fit more of this in if you want to see more. We have a live event. I'll be speaking in Vegas in December. We don't have a link for that, but if you go to our website and look at the events, and you come say hi to me, I'll give you a high five, and I'll get really excited that you're from Investor. So guys, thank you so much. I hope you like to use our system. Those rules are really important. If you need anything, I'm at your disposal. I'm at Anderson. Use that strategy session, and we're happy to look at your specific circumstances and make sure you're set up right.
Yeah, no, absolutely. And I think, listen, one idea, I always say, like, one idea, one strategy can save you literally money, time, energy. And as women, as busy women investors, we need that. So I'm just going to put her link in here again in case you guys didn't get it. Thank you, everyone, for being on here. Keep engaging with our community. We are here for you. We have a lot of exciting things coming down the pike for 2025. Stay tuned. But Gwendy, thank you so much for all the support and great content. And just folks, reach out to her. Anderson's been a great partner of ours, and they know what they're doing. So thanks again, Gwendy. Thank you, everyone.
Thank you so much.
All right. Have a good one. Take care.
You too.